Okay, here we go. This is episode 489, Debt Consultants.
This is Debt Free in 30. Here's your host, Doug Hoyes.
Ted, welcome to your first appearance in 2024.
Mm-hmm.
You and I have been fighting against debt consultants for 100 years.
That sounds like that fella in the windmill, right?
Tilting at windmills, exactly right. Well, and we're going to talk about all that. So question number one, what is a debt consultant? How would you define what a debt consultant is?
I won't use any derogatory language.
We can bleep it out.
I won't be vulgar.
I'll put my bleep button on here.
But effectively, they're folks that sell the service of helping you or advising you on how to deal with your debts. From our standpoint, what that really means is it's somebody that charges you a fee to tell you all the things that you can learn for free by calling a licensed insolvency trustee.
So I've got debt problems, and I go on the internet, and I find one of the ads for these guys.
And these ads are, it's need help with your debts? We can help. Call us or fill out our form or do whatever it is that they want you to do. So they don't have to tell you what they are, what their experience is, or where that information is going. It's just you need help, so you click on it.
And I contact them, and they're all very friendly.
They are very friendly.
Very helpful and everything. And they say, oh, yes, we can settle your debts for 20 cents on the dollar.
Right.
So I send them all my information.
Mm-hmm. Wait, we can settle your debts for 20 cents on the dollar, but you need to pay us a fee.
There's a fee.
Don't forget the fee.
There's a fee. So, okay, I send them all my information. They tell me that the fee is $2,000 or $3,000.
Right.
And they say, well, just go to your credit card or take a cash advance.
Probably.
So I send them the fee. And then what happens?
Well, so then they've got a list of licensed insolvency trustees that they deal with, and they'll fire your information off to whichever trustee they deemed is the one that you're going to work with.
And then that trustee does the proposal.
Does the actual work.
And how many files do you get from a debt consultant every month?
Well, absolutely none.
Zero.
First thing we do is we tell people that you're paying a fee that you don't need to pay. Funny that the debt consultants don't send us any work.
We make podcasts like this, and they all don't like us.
They don't like us very much.
So, although they do use all of our material for training purposes.
Of course they do.
I know that for a fact.
We have an extensive website.
So do you think the debt consultant problem has gotten worse over the last few years, better? Like what's your overall perception?
Well, so it's interesting. During the pandemic, I don't think it got any worse because there was no pressure on anyone. So the folks that were dealing with their debts were the individuals that, by their own personality type, they were going to deal with their debts. Now that we're back in the market where collection agencies are being actively engaged, the courts are actively engaged, the government is actively pursuing people, the consultant problem, for lack of a better term, is increasing again because there's all this demand out there for people. They don't know where to turn to get help. And so they take the path of least resistance. And that's that little ad that pops up on your computer saying, hey, you got a problem with your credit cards? We can help you.
Well, and the other thing that's changed since the pandemic, so we're going back almost 4 years now, is virtual.
Yes, the world is the pandemic changed the marketplace to that more than 50% of all the insolvency work now is being done virtually. And so that means you're not really sure who the hell you're dealing with.
But that also helps the debt consultants because in the old days, they'd have to be in your town so that they could send you to a trustee in your town, whereas now they can be anywhere in the country sending it anywhere.
Or the world.
Or the world. Yeah, exactly. They're not all in Canada. So the Office of the Superintendent of Bankruptcy is aware of this issue. And
who are they?
You have in front of you the position paper on the adverse effects of the debt advisory marketplace on the insolvency system that was issued on December 7th, 2023.
Right.
And one
Pearl
of
Harbor for the debt consultants.
That's it. Well, I
don't think they're going to feel that way.
That's the question.
Yep.
So one of the, I'll quote from this document here, which is I think like the second paragraph or something. It is not contrary to the Bankruptcy and Insolvency Act for a debtor to independently and based on complete and accurate information seek advice on how to manage their debt. Okay, we all agree with that.
Makes sense.
Right. You can go talk to a lawyer, an accountant, or anything. Providing debt management advice to individuals is legal, both federally and provincially. Okay, so what's the problem? Concerns arise when lead generators or debt advisors attract individuals to the insolvency system based on misleading information, or licensed insolvency trustees form relationships with these entities that conflict with the BIA, Code of Ethics for Trustees, or Superintendent's directives. So we talked about debt advisors. What's a lead generator?
It's a more general term. So it's a company that specializes in creating contacts between the consumer and who's ever providing the end product. In our case, it's insolvency services, but it can be anything. I mean, the most common one probably is cars. Right. So, hey, interested in this? And we'll connect you through to a dealer someplace that'll talk to you about that.
Well, or personal injury lawyers or anything like that. We'll find someone and send them through you.
Basically, it's somebody who specializes in manipulating data on the internet to reach out to very specific market people and connect them with folks that are selling those services.
Now, the OSB says that there are some gaps in regulation here.
Really?
So, debt advisors' activities are not regulated under any industry-specific provincial or federal legislation.
Correct.
Okay. So there's kind of a loophole here that is causing these people to exist.
Loophole the size of a tunnel.
Yeah. As a result, there are no education or experience requirements, no standards on service provided, and no caps on the fees that debt advisors may charge.
Anyone can call themselves a debt advisor.
Anybody. And obviously, in our case, we are licensed insolvency trustees. There are definitely caps on our fees because they're set by the government. There are definitely education and experience requirements.
And there are consequences if we advertise in false or misleading ways.
Where there aren't if you're not regulated. Again, I'm quoting from the Office of the Superintendent of Bankruptcy. It is worth noting that the profit orientation of an organization, whether for-profit or not for-profit, does not dictate the quality or ethicality of its business practices or behaviors. Non-profit organizations are different from charitable organizations which operate under a distinct set of regulations and objectives. Okay.
So that's a shot at a couple of large not-for-profits,
yes,
I'm guessing?
That's exactly what they're doing. And that's true. Not for profit means you don't make a profit.
Doesn't mean that. It means your objective is not to generate a profit.
Whereas a charitable organization is to do some charitable work.
80% of your net revenues have to be redistributed to whatever that charitable activity is.
So totally different thing. And obviously there are debt consultants, credit counselors, whatever, who kind of are straddling the line there.
Well, most of the charitable organizations got pushed out of this business.
Yes, that's exactly right. They're
gone.
They're gone. It's not for profit. It's not charitable. So and the reason they pushed them out is because the government said, wait a minute, you're just a collection agency.
Right.
And all of those agencies have to be registered under the Ontario Collection Agencies Act. So that kind of proves it. The debt advisory marketplace does not have a certification body that is widely recognized, reputable, or enforces consistent standards across the industry. Well, they don't have anything. That's kind of the problem. Okay, so what is the problem? Well, problem number one, bad advice.
Yes, okay.
So give me an example of bad advice. Like, what would a debt consultant say that is something that you would not be saying?
That's a good question. So I certainly wouldn't right off the top of my head say, oh, I can reduce your debt to 20 cents on the dollar. There's no way for me to know that without asking you some specific questions.
Yeah, and so
Yet it's a hook.
Right, it's a hook. And so the debt consultant is going to say, well, okay, the proposal is going to cost $200 a month.
Right.
And they don't really care what the numbers are. They just want to earn their fee.
Yep.
And then when they send the person to the trustee looks at it and goes, well, wait a minute, based on the level of your debt and your income and everything, this has to be $500 a month or the creditors aren't going to accept it.
Right.
And of course, then the trustee's the bad guy.
Yep. Well, then it looks like a bait and switch.
And which is exactly what it is.
Yep.
The second big problem is it's costly.
Right.
We're going to talk about that. And then the third big problem is it delays the debtor's opportunity to seek the right solution to their financial challenges.
Right. That adds another layer to the onion.
Yeah. So it's kind of like, okay, I'm having a heart attack. I have to go and see a consultant and talk to them for 2 weeks before I get to see a doctor. That doesn't sound good to me.
Right.
Right? Probably better to see the doctor right away. Okay. Let's get into the interesting stuff here. There is a section in the superintendent's report called Cost to Debtors.
Oh, right.
Debt advisors may impose significant costs on debtors. The OSB collects data on financial advice and the corresponding fees paid by debtors within 6 months prior to an insolvency filing. So how does the OSB collect that data?
Right. So there's a form that trustees are required to sign off on. So is the debtor when a proposal or a bankruptcy is filed saying, have you talked to anybody before you talked to the trustee? Did you pay him any fees? That's the only method they have of tracking.
And you have to put the name of the person you talked to and a whole bunch of information.
So it's all voluntary disclosure.
Yeah. So whether it's accurate or not, that's a different story.
Right.
And in 1922, and in 2022, started collecting data on the amount committed to be paid post-insolvency.
Right.
Ooh, we're going to talk about that. Fees paid to debt advisors before filing amounted to approximately $13.8 million in 2021 and $8.3 million in 2022. The fees committed to be paid post-filing were approximately $7.6 million in 2022. Now, you made the comment earlier, because you look at that and you go, oh, well, things are getting better. It was $14 million in 2021 and only $8 million in 2022.
No, it's $16 million in 2022 because it's pre and post added together.
Well, yes,
anyway.
and they didn't split it out.
Right.
I think probably what happened was we all know 2022 was a year of relatively low insolvencies.
Right.
And as a result, there was just less happening. So they're not telling us per person, they're telling us in total.
Right.
But if you take the 8.3 million and you add the 7.6 million, that's $16 million. There were 16,630 consumer proposals filed that year. That's about $1,000 a file. Now, of course,
your math's wrong somewhere. You slipped a decimal place.
It's 22. In 2022, debt advisors provided financial advice on approximately 22% of consumer proposals.
Okay.
22% of consumer proposals is 16,630.
All right.
So of the people who paid a debt consultant,
the average is $1,000.
The average is $1,000. But as I said, I think 2022 is a low number because the OSB started collecting data through the year.
And averages are always dangerous because it doesn't tell you how many are above or below.
Right. Mm-hmm. There could be somebody who paid $50 and everybody else could be paying $3,000.
Right.
I think the point is that's a scam.
It is. Well, it's money that you don't have to pay. You certainly can talk to your lawyer or accountant, but call any licensed insolvency trustee and we'll have the same conversation with you. And we're not allowed to charge you a fee for that conversation.
Because that's the rules.
Right.
Yeah. The rule says we start charging money when the procedure starts. Mm-hmm. So, and our fees are governed by the government. It's not like we're making them up. All trustees get the same percentage of what's in the pot. And that starts when you officially file the proposal. Right. So if a debtor comes to you and says, hey, Ted, I hear you're like the greatest guy ever. I'd really like you to do my proposal. I'd like to give you $1,000 right now to get the process started. What do?
I won't take it.
So, or if he says, no, I want to make sure my first couple of payments are covered, then what do?
I could put it in a general trust account, but I can't actually take it as revenue until the file is actually submitted to the government.
Because what you'd be doing is putting it in your general trust account, taking that $1,000, and then when the proposal starts, you put it into the proposal and you get your fees based on that.
Correct.
So the point is we can't take upfront fees. Yep. It's pretty much as simple as that.
And that's a great acid test, folks. If somebody, the first thing they say to you is, I need money right now, you're not talking to a licensed insolvency trustee, and so you got to question whether or not you're actually getting the best advice you should be getting.
Yeah, unless you're talking to a lawyer or an accountant, you're getting scammed.
Probably.
It's almost as simple as that.
Yep.
Now, the Office of the Superintendent of Bankruptcy lists a whole bunch of issues with dealing with a debt consultant.
Yep.
Failing to accurately determine the debtor's liabilities at the time of the filing, especially the liabilities to debt advisors. Yeah, that's pretty bad. Failing to obtain independent valuations of a debtor's major assets and instead accepting valuations from debt advisors or related companies. So, okay, we're gonna scam the creditors here, Ted.
Okay.
Guy comes in to see you and he says, yeah, here's my situation. I got $50,000 worth of debt, but I also own a house and I have this investment, I have this and this. And you say to him, well, okay, we have to offer enough in the proposal that it's better for the creditors than if you went bankrupt.
Right.
And when you look at the value of your house and your assets and everything, it's way more than your $50,000. So probably a consumer proposal doesn't work. Mm-hmm. But the debt advisor would say, oh, here's what we're going to do.
Yep.
Keep your mouth shut. Don't tell the trustee you own a house. Don't tell him you got this investment. Don't disclose it. Now your assets look less.
Right.
Now, that's fraud, right? Mm-hmm. It's just plain out and out fraud.
And it's not likely to work because when you fire off the information to the creditors in the formal proposal package, they'll send us back a letter saying, well, wait a minute, what about the house? What about the RSP we've got on file? What about this?
Everything's in a computer now.
That's right.
And so when you applied for the credit card, you would have told them you owned a house.
Right.
And it's not that hard to do a search and see who does own a house. Mm-hmm. So you're just kind of getting scammed there is what happens. Okay, so what's the OSB going to do about it? So they have a section called position.
Wait a minute, I'm going to hold my breath till you give me the answer.
Here we go. And again, I'm quoting from the document here. LITs must avoid knowingly engaging with debt advisors or lead generators who violate the BIA, the Competition Act, or provincial consumer protection laws. Okay, we should not knowingly engage with crooks. Okay, hasn't that always been the case?
Well, that's motherhood.
Yeah, exactly. That's motherhood. So, and they give a whole bunch of examples. Examples of activities which LITs ought to be aware of include debt advisors advertising that they are LITs. Yeah, okay, that'd be pretty bad. That's like me advising that I'm a medical doctor. Yeah, I don't think that's legit. debt advisors coaching debtors on how to circumvent the requirements of the BA. Well, that's what we just talked about. That's obviously pretty bad. So, okay. Conclusion. Let's go to the end of this report.
The end of the report.
You've got the report in front of you.
I'm
and
flipping
it's
to the end of the report.
pages. We don't want to go through the whole thing.
Gotcha.
Conclusion. What's the OSB going to do? So the report itself is, I don't know, what's that, 10, 12 pages long?
Yep.
And the conclusion is one paragraph.
And folks, you can read this because we're going to put the links on the site. We always do.
You can read it. So, conclusion. The OSB will specifically target the issues identified in this position paper and any other matters as they arise if they are contrary to the regulatory framework. Okay, that sounds good.
Right.
To address non-compliance, the OSB has launched and will continue to initiate professional conduct investigations where LITs contravene the BIA, the rules, or the superintendent's directives. Okay, so they're going to look into it. I guess that's the first step. The OSB will consider all available options to address non-compliance, including licensing measures, civil and criminal proceedings. Wow. So what is your prediction, Ted, as to how much criminal proceedings we're going to see in 2024?
Yeah, I stopped holding my breath as soon as you started speaking, by the way.
So additionally, the OSB will continue to collaborate with other federal and provincial regulators, even though they've already said these people are not regulated, to prevent and address non-compliance and the negative impacts of debt advisors on the integrity of the Canadian insolvency system, on individual debtors, and on creditors. So, do you think the OSB will do anything?
I think it's highly unlikely.
And I agree.
I mean, the hammer that they have is that they can do something to the licensed insolvency trustees that deal with these guys. Okay,
now we're getting to the next.
So you can't actually go after the fellas that are being the crooks, but you can go after their fence, the people that's moving the product for them.
Okay, now you're getting to the meat of the issue here,
right?
Because that's exactly right. You want to go after the person who is accepting the work. So trying to shut down a debt advisor who is not regulated.
Right. Who could just change their name and start running the ads tomorrow, anyways. Right?
So going after them is pointless. It's the licensed insolvency trustee who is benefiting by getting work from these scam artists and giving it the air of legitimacy. Mm-hmm. So what could the OSB do to trustees?
Well, the easiest fix, anytime that there's some sort of money disclosed as being paid to a third party or prior to someone filing, should be a direct deduction from the trustee's approved fees. That's an easy fix. They could do that tomorrow by the way that they regulate our industry. Every file that we generate eventually gets audited by the OSB, Office of the Superintendent of Bankruptcy, and they issue a letter. It's called a comment letter that tells us, yes, we approve your fees. So instead of doing that, they could say, well, we note that on the assessment form, you paid $1,500 in fees to Joe's Debt Services, and so now we're deducting $1,500 from your permitted fees.
Well, it's a good idea, but there's two problems with that.
It's not going to happen.
It's not going to happen. Number one, they would have to change the regulations to actually be able to change the fees.
Right.
And for the government to change any kind of rules takes years and years and years because it's not just doing it.
Right.
Second problem is, if they were to do that, then that would just encourage trustees to lie on the forms.
Correct. So that would be the consequence of their action would be people would just stop disclosing it. Now you're breaking the rules, so.
Well, yeah, but
but if you break the rules and you can prove it, then you have other licensing issues that they can take steps to.
Now,
and that's easier than proving this first thing.
I agree. Now, I cannot get inside the mind of the superintendent. Right. I don't have the ability to read minds. Mm-hmm. But I'm going to give her the benefit of the doubt and assume that she's got a grand plan here. Okay?
Beyond a pension in 5 years.
No comment. We'll bleep that part out. Her grand plan might be that, okay, I realize there's a problem. Like, we all know it. We've got all the data. We've seen it. And just for the record, this report that was issued in December of 2023 follows up a very similar report that was issued 5 years earlier saying exactly the same thing.
Right.
So now, she wasn't the superintendent 5 years ago, but this is not a brand new problem. They know who's doing it. They know what the issues are. Nothing was done for 5 years. So to give her the benefit of the doubt, maybe what she's thinking is, okay, you know what? I have not made it explicitly clear that this is wrong.
And it hasn't been a priority to deal with it.
And now I'm making it a priority. So it's kind of like yelling at your kid when they get home at 10 after 11 at night.
Right.
When you didn't explicitly tell them that curfew was 11 o'clock.
Or 10 o'clock.
Or your kids are younger, so they're probably not out too late. So
Right.
you got to lay down the law first. Here's the expectation. The speed limit is 100.
Right.
Okay. Unless you're out in Windsor, it's 110 on the 401. I found that out over Christmas. So the speed limit is 100. We tell you what the speed limit is. We put up signs, we put up cops, whatever. And then once everyone knows what the rules is, if you break it, then we bring the hammer down. Well, okay.
Right.
So she has now in this report listed very specifically, you can't do this. This isn't right. This isn't right. This is right.
Right.
So there's no confusion now. Everyone's got the report. Everyone's had time to read it.
Okay.
So now that it's very clear what's wrong, okay, now I can bring the hammer
So
down.
the next step is enforcement.
Right.
And we don't anticipate that we'll see that.
Yeah, and I mean, I will be stunned if there are criminal proceedings because I don't know what criminal thing is being violated by
fraud.
Yeah, okay, maybe.
If you're misrepresenting yourself as an LIT when you're not, that's certainly fraud.
Well, if you're deliberately hiding assets and things like that, that would be fraud too. So that would be the best case scenario that, okay, I've told everyone what the rules are. I'm going to give you a bit of time to sever your relationships with these bad guys. And then I'm bringing down the hammer.
Right.
That'd be fantastic. Now, back to what can actually be done about that. So your idea about adjusting the fees and everything,
It's not gonna happen.
that'd be great, but it's too hard.
Right.
I think what I would do, like, what are governments really good at doing? What are bureaucrats really good at doing?
Well, coming up the works.
Gumming up the
Right.
works.
It's like
exactly.
It's what the lettuce in the Japan, right? It lands on the dock, and you don't say there's anything wrong with it. You just delay it to the point where it's useless.
And then you got to throw it out.
Right.
Gumming up the works. So if I was the superintendent, what I would be doing is gumming up the works.
So you'd issue a negative comment letter that requires somebody to have court review or something.
I wouldn't even take it to that extent.
I would just slow down the process?
Yeah. So I know who the trustees are who are doing this bad stuff. Everybody knows who they are. I can give you the list, but I don't want to get sued. So what I would do is I'd say, okay, every consumer proposal that's filed, we are going to request a creditors meeting.
Right.
Because the superintendent has the power to do that.
That's true.
And we are going to do an examination of the debtor. Again, fully within their power, the rules already exist. So what we're going to do is examine the debtor. We can do this over the phone or Zoom or Teams or whatever. And I'm going to say, hey, Mr. Debtor, who did you pay? Why did you pay? Did you understand that you were getting scammed? You didn't have to pay that money. You could have gone directly, whatever. And now nothing would come of it, because it's just talk.
Right.
But if the trustee had to attend a creditors meeting for every single proposal they filed, and they had to explain to the debtor why the superintendent was asking why they paid these fees, then that would really gum up the works. It would make it a lot more difficult to operate. And a bunch of their clients would get upset and say, wait a minute, I didn't have to pay that money.
Right.
I'm withdrawing my proposal.
I don't know that would happen, but okay.
Well, if the superintendent was right on top of it, as soon as the proposal's filed 2 days later, you're setting up the exam. If you get the exam done before the 45-day voting period is up, the debtor can withdraw the proposal, go to another trustee.
Right.
Now, the superintendent can't suggest that.
Right.
But I don't know if it would be that hard for them to put two and two together. So I blame the LITs for this problem.
Certainly.
And so that's who you've got to attack, as you said.
Yep.
But there's another section in this report that I skipped over. It's called cost to creditors. The significant cost imposed on debtors through debt advisor fees may reduce returns to creditors. The timing and structure of their fees generally mean they are prioritized over the debtor's other creditors. In addition, the OSB is aware of instances where a debt advisor has encouraged debtors to charge the fees to their credit card, knowing that this debt will be included in the insolvency filing.
Sure.
The practice allows the debt advisor to get paid, but leaves the credit card issuers to absorb the debt. Okay, so who's getting screwed here? Well, the creditors.
Wow.
Now,
effectively, that means everybody.
Yes.
Right.
Now, you and I aren't going to hold any tag days for the creditors because we're talking about the big, huge banks who make billions of dollars.
Right.
But who else can stop this? The creditors.
Sure.
So if I was one of the big banks or credit card issuers and I realized that, hey, wait a minute, this is what's going on, what could I do?
Yeah. So you could vote no on every proposal. You could request creditors meetings, and then you could send a list of questions. You could create a lot more work.
You could also gum up the works.
Right.
So now I have had this discussion with a couple of major creditor representatives.
Wow. 2 or 3 times a year you present to these large
Yes,
conferences.
I've been to a couple of conferences recently, and I've had this discussion with them. And they've said to me, you know what? We totally agree with everything you're saying.
But we're not going to do it.
But we're not going to do it because the big bank doesn't want to be the guy who votes against the proposal and pushes someone into bankruptcy.
Right.
We would rather get scammed for a couple of $1,000 on a cash advance on our card than push someone into bankruptcy. And my response to them is, well, you're not pushing someone into bankruptcy.
Right.
If you reject the proposal, they can go file with somebody else. I mean, there's some time requirements and whatnot, but and you don't have to do this forever.
It would be pretty self-correcting.
Pretty self-correcting. So I've got this list of the trustees who are doing this bad stuff. I'm the big bank. So every proposal I get from that trustee, I'm going to vote no. Mm-hmm. And if I do that for 2 or 3 months, then the trustee is not generating any income because all their proposals are being killed.
Right. And the debt consultant will just refer them to a different trustee.
Right. But then at least, okay, the next trustee has to then...
then you got to catch on. So, yeah.
Right. But my assumption is that there are a small subset of trustees who are doing this. I don't think it's every trustee in the country that is taking work.
Right.
So if the bad trustees aren't getting work, yes, you're right, the debt consultant will go to the next trustee, but there are only so many of them. Right. Eventually they all get pushed out of business. And again, the bank is not putting them into bankruptcy. If a proposal is withdrawn or rejected, you can file another one. Now, if it's annulled because you didn't pay, that's a different story. So that would be my, I think that's who can solve it. Mm. Now, the rest of my recommendation here, which I have made to the superintendent directly,
right?
You mentioned earlier the assessment certificate, which is a piece of paper where we put down, here's who got paid in advance. That piece of paper doesn't go to the creditors.
Right.
They don't get to see it. That's stupid.
Mm-hmm.
So I think the answer is that piece of paper should go to the creditors along with the guy's budget and list of debts and list of assets and everything else. And that way the creditors can then make an informed decision.
Assuming it's been filled out correctly.
Right.
But we have to assume that.
If it hasn't been filled out correctly and yet the creditors know that, this is a trustee who has a disproportionately high number of proposals versus bankruptcies or
perhaps hundreds and hundreds of files with only one office.
Yes, exactly. It's not hard to figure out who these people are.
Right.
And so either they're going to disclose the information and you can take action, or they don't disclose it and you got an even bigger problem.
Right.
But you got to include that piece of paper with the documents. And I have said to the major creditors, look, I'm happy to voluntarily send you that piece of paper.
Right.
And they've said, well, there's systems issues and
we don't have to do with it.
Yeah. So, and I've mentioned this to the Office of the Superintendent of Bankruptcy. Hey, just make a rule that you got to put that piece of paper in it. It's would take no effort whatsoever. Mm-hmm. So if they do that, maybe we can get a bit more exposure to this. I, however, am with you. I'm not holding my breath. I don't expect a lot. My final comment. The other solution to this is education.
Sure.
That's why we're doing this podcast.
Yep, and that's why there's all sorts of blog posts on our website. I mean, we're on this thing numerous times every year.
Years and years, and we've been doing it. We're trying to get the word out. You said it originally. If you're going to someone and they're charging you an upfront fee, it's a scam.
Right.
It's a real simple heuristic. If you're trying to figure out, hey, are they good or are they not? So if you avoid those upfront scams, then the problem goes away. So that's...
Well, and we didn't touch on this, and it was kind of mentioned a couple of times. There are now debt consultants that are charging fees even after you file. Mm-hmm. And so it's not just that they're charging you a fee up front. If somebody's asking you to make payments to 2 different bodies as part of your proposal, that's got to be a scam too.
Yeah, it's a very good scam. So the proposal is going to be $300 a month. So it's like, well, the first 6 payments come to us, and then the final 54 go to the trustee.
Right.
Now, how the creditors are even allowing that to happen, I don't know. I think what happens in a lot of cases is the proposal does not officially get filed until 6 months into it,
right,
which means you're putting up with the phone calls and all the rest of it. Hopefully you don't get sued in the process. Mm-hmm. But yes, that would be the other obvious warning sign if there's payments ongoing to the person who isn't the trustee. So again, that's why we do these shows, so people can understand what's going on.
Follow the money.
I'm pretty sure we'll be doing the same show again next year.
I'm sure we will.
Mark it down in your calendars. But this is, I believe, an easy problem to identify because the superintendent's already done it.
Yep.
And it's an easy problem to solve. It's just going to take 2 or 3 months of,
Somebody has to have the will to solve it.
And so if you know anybody who works at a big bank Why don't you talk to them and let them know, and maybe they can correct it. So there you go. That is debt consultants. What we think should be done about them. Neither you or I are very optimistic. We'll probably be doing this show again, but I don't know. Maybe we'll be pleasantly surprised. Right. Who knows?
I mean, again, we don't encounter a lot of this because the debt consultants know. We're going to tell people. I mean, they just don't refer them to us because we tell them it's wrong.
We're not seeing it, so it's and that's kind of the way we like it. So there you go. That is our show for today. If you're watching on YouTube, there's a place to put comments. So if you disagree with what you're saying, if you've got any other way to gum up the works, please put a note down there. We always like it if you like and subscribe, hit the notification bell, new show every Saturday morning. Most people are not watching this show. I don't know why. They don't like to see us. They prefer to just hear us.
Perfect faces for radio.
We have great radio voices. So if you're listening to this on Spotify, Apple Podcasts, all the different podcasting apps, same thing. Subscribe and you will get the new podcast every week. That is our show for today. Until next week, thanks for listening. I'm Doug Hoyes. That was Debt Free in 30.